Now, when you give a may clause over there, when you say that the Parliament may divide it on the basis of the GST Council recommendations, and you use a shall for compensation in clause 18, you are basically giving importance to a short-term measure and basically forgetting a long-term measure. Now, what do you think that it would be a better idea if we had used the word shall again in Article 269A and say that it is only on the basis of the GST Council's recommendations? Would the IGST also be shared till perpetuity? Then don't you think that this fears about what the compensation would be misplaced?
First thing, IGST is not supposed to create a pool which center sits on. IGST in principle is supposed to be a pass-through. Half of IGST is center's own revenue it is supposed to keep. The other half of IGST is supposed to be claimed as input tax credit in the receiving state, which is the part that will not be claimed. Whenever there is a B2C transaction on which IGST might be collected, that part will remain unclaimed. You are not talking about big monies here. IGST is different from compensation.
Yes.
Compensation is a different animal.
Yes.
When we are talking about IGST, we are talking about IGST is designed as a mechanism which takes revenues from one state and delivers them to the other state. So it's meant to deliver it to the destination state. And the mechanism by which it delivers it is when the destination state claims an input tax credit. So all the revenues will get used up in the process of claiming ITC. Only who is not going to claim ITC in the destination state? A consumer, because he doesn't have any locus standi to ask for ITC. So only those revenues which are sold by a B in state A to a C in the other state will lodge with the IGST mechanism. The rest of the money gets distributed.
My question on that distribution, and you see the wording, such tax shall be apportioned between the union and the state in the manner as may be provided by the Parliament by law on the recommendations of the GST Council. So basically now you are not apportioned the money. The Parliament may consider the recommendations of the GST Council. If you use it as a directive provision, basically just like the Finance Commission, I can do whatever I want. The Parliament may take it or may not take it. Now, you are talking about a tax system where the states also have a considerable say. So don't you think that the state's say should have been preserved there again, even in the division of the IGST?
You can preserve it, but I think it's a small issue. You can preserve everything, but I believe it's a small issue. It's not. I think states are worrying about so many big things. There's not big money locked in there, so, or it's not intended to have big lock-ins there. Okay.
Thank you, ma'am, for evaluating the pros and cons of the GST through the prism of policy and economics. We now have Dr. Gop Kumar, who will now be addressing us on the critical issues surrounding the structure of the GST. Dr. Gop Kumar is currently a PhD in law and teaching at the Gulati Institute of Finance and Taxation. He has researched extensively on fiscal federalism and has contributed several articles and books on this subject. Sir has also incidentally been instrumental and the main architect of the Kerala VAT Act. And sir, we are very happy to have you here. We are having...
You already introduced me.
So reintroduce me. So do you want me to reintroduce you?
No.
Because everyone already heard it. Yes, sir. We'll now be having Dr. Gopakumar, who will be addressing us on the critical issues surrounding the structure of the GST.
GST Council.
GST Council, I'm so sorry.
Honorable Vice Chancellor, Mr. Sadish Pai, Professor Vijay Kumar, Mr. Khalid Anwar, and Mr. A.K. Ganguly, and my dear friends. I will be speaking on the structure and role of the GST Council. At the outset, I would like to say, GST is now assured. notwithstanding the fact that we have been persistently trying for the last 10 years. Because of clause 19 of the Constitution under First Amendment Act, there is no option before the union and the state governments other than to implement GST, because the time given is only for 1 year post Constitution Amendment Act, and if the governments do not implement it, they will not be able to collect the taxes which they have been collecting under various heads. So now it is ensured, at least by September, GST will be a reality in this country. But what will be the operational structure of GST is a matter of serious concern. What I understand is the GST will be regulated and controlled by two organizations, GST Council and GST Network. GST Council is a constitutional body constituted under Article 279A, and GST Network is a company of which 49% of shares will be held by Government of India, state governments and union territories, and 51% of share will be held by private finance institutions. These two institutions are going to control, regulate and dictate the GST. If the GST Council is to make recommendations to the union and the state governments on all subjects with a residuary entry, residuary statement that everything GST Council will be making recommendations. GST Network, the company, will be providing the technical platform, which is being developed by Infosys for a contract of 1,380 crores. The recommendations which the GST Council, there was a question whether it is, if it is recommendatory, will it be binding? No. Recommendations will not be binding. But the recommendations of the GST Council will be binding, because there is no other option. There is no other option before the state government, because state government is party to this recommendation. Union government is party to the recommendation. And if the state governments do not accept the recommendations, what will be the legal implications of it? So things have to be seriously deliberated. So GST Council should be understood along with the operational structure and parameters of GST Network, that company also. Okay. The GST Council is not by accident. It has been a result of deliberate political decisions. Indian Constitution, which postulates a federal polity, demarcates and distributes the legislative subjects between union and the states, including the subjects to raise revenue for meeting their positive obligations. And Article 265 mandates that no government shall be competent to levy or collect tax without the authority of law, and the authority of law under Article 265 simply means that it should be a statute enacted by a competent legislature. And through judicial rulings, the fundamental principles of Indian taxation have been said that there should be a specific tax entry in the appropriate legislative list, and the tax must be mutually exclusive. Taxing power should be mutually exclusive. Both these principles have been considered to be the touchstones for determining the validity of a fiscal statute. In the GST regime, we are going to violate both these principles. There is no specific tax entry in any of the list for levying GST. Instead, we are going to levy GST under a specific article, that is 246A. On the other side, the mutual exclusivity is also removed. Both the union and the state governments are going to levy and collect tax on the same event and on the same tax base when there is a intrastate supply of goods or services. So both these, the concurrent taxation, which raises an apprehension that when two different agencies were assigned with the power to levy tax on the same event and on the same tax base, inconsistencies are naturally to result from this arrangement. And 246A has ousted the operation of 254, which was actually an article dealing with the inconsistencies of laws made by the union and the states. So by the opening non-obstant clause in Article 246A, 254 is ousted. Now there is no agency, there is no mechanism to resolve any dispute or to develop a consensus or to remove the inconsistencies of laws. So they thought of setting up an institution where which can act as a conciliatory forum. That may be the reason. That may be the reason why GST Council has been set up. It is expected that the GST Council will act as a conciliatory forum between the union and the states. So, the efficacy of operation of the GST Council, according to me, should be tested whether it is capable to or whether it is competent to resolve the disputes or rather create a consensus between the constituent parties, the union and the states. So my presentation is on this basis. GST Council already, one presentation has been there anyway. I will just. It is to be constituted within 60 days on passing of the Constitutional Amendment Act. Constitutional Amendment Act passed on 8th September and the GST Council was notified on 12 September 2016 and the first meeting of the Council was held on 22/9/2016 and as per Mr. Arun Goyal, almost 10 meetings have been already taken place and very important decisions also have been, or resolutions also have been passed. The scope of the GST Council is for making recommendations to the union and the state governments on GST. By the letters, it is provided that it is only recommendatory in nature. There is no binding nature. But if you go through the procedure and the political setup, it can be easily understood that it is not recommendatory, it is dictate. It is not recommendatory, it is dictating. GST Council will be actually dictating, or rather actually setting the principles how the GST should be operated in the country. And it is said that while taking a decision, it shall be guided by need for a harmonized structure of GST and for the development of a harmonized national market for goods and services. So these are the directions given to the GST Council. You take the decision, but whenever you take a decision, you should think that your decision should be conducive for setting the harmonized structure of GST and for setting up a harmonized national market for goods and services. That's all stated. Who is the authority going to determine whether the resolutions passed by the GST Council are in consonance with the directions like it is for supporting the harmonized structure of GST or developing a harmonized national market for goods and services? There is nothing like that. It's only a statement. And if suppose if GST Council doesn't take, or rather the resolutions of the GST Council is not in conformity with the principles, what should be the remedy? Whether such decision should be discarded, or the government should not be, or should not be compelled to follow it, or something like that. Nothing is said. It's only said that, okay, GST Council, when you take a decision, think that you are taking the decision for developing a national, harmonized national market of goods and services. Or all your decision should be for the harmonized structure of goods and services tax. But how it is to be determined, how it should be evaluated, nothing is said in the constitution. And no remedy is also stated. GST Council, the Union Finance Minister is the chairperson, Union Minister of State in charge of Revenue for Finance member, Minister of IC for Finance or Taxation, or these all things have been discussed in our earlier sessions. GST Council role and responsibility is clearly said that to make recommendations to the Union and the state governments on serious matters relating to the implementation of GST. One is the levies which may be subsumed in the GST. We have 21 taxes on goods and services. 12 taxes for the states and 8 taxes for the Union plus 1 residuary entry. So altogether it is, we can say that 21 indirect taxes on goods or services in India under the Indian Constitution. And the general orientation of goods and services tax was to subsume all these taxes into a single one and to apply it across the board whenever there is a supply of goods or services. But going through the Constitution Amendment Act, one will easily understand that out of these 21 taxes, only 4 or 5 taxes have been eliminated. All other taxes will continue to remain in the statute book. Because petroleum products, 5 petroleum products and the alcoholic liquor for human consumption are kept outside the GST regime, the GST net. And for such commodities, all these taxes have to remain. So GST will remain. Customs duty, the entry itself, entry 83 of Union List has not been amended. Excise duty will remain. VAT will remain. General sales tax will remain. Only service tax, luxury tax, income tax, such except the service, inconsequential taxes only are eliminated. Otherwise, majority of the portion, almost 40% of the total tax collected by own tax revenue or rather own tax revenue of the state, the petroleum products and the alcoholic liquor for human consumption. For such taxes, almost for the 40% of the own tax revenues of the states, all the tax laws will remain. So there must be, or rather at the subsequent period, there must be an agency which has to take these all things into account and say that okay, these levies should be subsumed down to the GST, or rather it should be eliminated. And goods and services that may be subjected to or exempted from GST. The practices so far was that it was the state government's prerogative that so and so item should be exempted from tax, or there should be a concessional rate of tax. Like that. In the case of excise duty, it was the Union government's prerogative. Now it has gone to the GST Council and say that they will decide, the GST Council will decide that which are the goods and services that are going to be exempted. Model GST laws, principles of levy, principles of the place of supply. Already 2 drafts have been prepared by the GST Council Secretariat, the latest one in November. And we all expect that by March, the final draft will be out. So, the GST Council is preparing the law. It's only recommendatory in nature. The GST Council is preparing the law which is as per the 279A, it is only recommendatory. And what will be the role of the state governments or the Union Parliament, state legislative assemblies and the Union Parliament? Just to ratify. GST Council Secretariat will be preparing the law, the model laws which we all have received. And our role will be only to see all the full stop, comma, hyphen, etc. are properly placed, if not amended, and ratify it in the legislature. That's what I said, that although it is at recommendatory, it is not purely recommendatory. In some cases, it is actually dictating. Because the principles of levy and the place of supply rules, which have not been discussed in detail in our government sectors, state government sectors, but it has been decided by the GST Council Secretariat. Apportionment of IGST. One of my friends asked to some article under why IGST should not be brought under the common divisible pool, which can be apportioned, which can be divided between union and the state by the state finance, the Union Finance Commission. Nobody knows the reason, and Professor Rao was rightly pointed out, it's not a big amount. IGST is supposed to be a clearinghouse mechanism, but after the clearinghouse mechanism also, there will be considerable amount with IGST, and that IGST will be under the control of the union government, which may be apportioned on the basis of a parliamentary enactment, on the basis of a recommendation of the GST Council. So these many processes, recommendation by the GST Council, then it goes to the parliamentary enactment, then parliamentary, on the basis of parliamentary enactment, another mechanism has to be developed for the distribution of or the apportionment of the IGST between the union and the states. Threshold of limit of turnover of GST. So these all things, see, kindly go through it. These are all very serious issues which is going to decide the nature of GST in our country. You can say at the last K, you can say any other matter relating to GST as the council may decide. Apart from all these things, or rather in addition to all these powers, if anything is left out, that is also brought. Any other matter. So anything related to GST will be within the domain of GST Council to recommend. Whether it is actual recommendation or not, is a matter to be decided upon. Coming to the procedure. Quorum we have decided, we have said that is 1/2. Procedure shall be determined by the council itself. Decision by majority of not less than 3/4 of weighted votes of the members present and voting. Weightage of votes, its votes of the central government shall have the weightage of 1/3, that is 33.33% of the total votes cast. Votes of all the state governments taken together, which includes the two union territories with legislatures, shall have the weightage of 2/3, that is 66.67% of the total votes cast. And this is the formula given. Total weighted votes in favor of a proposal. In a situation where all the members are present, you can calculate it like this. Total weighted votes in favor of the proposal will be weighted votes of the union, that is the 33%, 33.33% plus weighted votes of states in favor of a proposal is equal to weighted votes of all states present and voting, that is 2/3, into number of states voting in favor of the proposal divided by number of states present and voting. So this should be 3/4 of the total weighted votes. Then only the resolution will be passed. Okay. Concern of the states is the majority required for passing a resolution and the share of weighted votes of the union and the state government show that no resolution shall be passed in the council even if supported by all states unless backed by the union government. But the union government will be able to pass a resolution if it has the support of 20 states. Okay. Next point is, the council shall establish a mechanism to adjudicate any dispute arising out of the recommendation or implementation thereof between Government of India and one or more states, between Government of India and any state or states on one side and one or more other states on the other side, or between two or more states. There is another article in our constitution which has given the same, the verbatim. That is Article 131 of Indian Constitution, that is dealing with the original jurisdiction of the Supreme Court, which says that in exclusion of all other courts, whenever there is a dispute, it should be taken originally to the Supreme Court. That is Article 131. Here we say that when there is a dispute between Union and the states, which arising out of the recommendations or implementation thereof, GST Council shall establish a mechanism to adjudicate. It is not any other word, it is adjudicate. Adjudication has specific technical meaning. Is it contrary to Article 131? If it is contrary to 131, what will be the status of this provision? The pertinent questions. What criteria should be followed to determine whether the GST Council has been guided by the need for a harmonized structure of GST or for the development of a harmonized national market for goods and service while passing a resolution? What we should follow actually? What is the remedy if a decision has not followed the above principles? Suppose these principles have not been followed by the GST Council. Can someone approach the court? Is that justiciable? Can someone go to the court and say that, sir, they have taken a decision which is not actually helpful for the development of harmonized national market, so it should be quashed? If somebody cannot go there and get it quashed if it is second decision, what is the necessity of this provision? Is it mandatory for the council to